We have loaded my plans. Network. We have back in action. Tell your brother and tell your sister we have back in action. Okay? Maybe I have to tell the teacher about share this high court.
Keke nawa
atenze keke yanso ate akavalinga buli kibo nawo wathadinga gitekayo mama agikweka nagira no gamba ubona am strikinga no gamba wae kamuleka
This media, the worry was in let's make it up. And the court is full to capacity. Is a chair, Dr. Kizza Besigye, live here. You have a job, I'm later. Anytime from now, you have later. It is the heaven media, let's make it happen. Let's make it happen again.
Mulabi wange yakwaniriza nate lwetuli nnyo enkya ya leero tusuubira Dr Kizza Besigye Lutale essaawa yonna Uganda leero bakomawo babanga basaba okuyingirira basuubumuzi bategeeza nti bali batekereza ebyetaagisa byonna okusobola nga bafuna okwenyigira naye Kizza Besigye wabulabe oba wabulabe so yinza lwakiyityamu so kati bano basalawo nebaddayo okusaba kwanze okubadde kumaze almost emyezi esatu nga tebafuna so kati feriyase oluvannyuma lwanti nkazoziwadde bakomayo omuwandiisi n'abagamba tanafuna fayiro yaabwe newankubadde ate kyewegesa nti okashonera nti yafuluma tebeebuuza nti okashonera nti yafuluma etya aliwo yenna mukulu we omuntu yenna asobola okuba nti omuntu yeewuunya n'abuuza nti bafunira batya hearing date ne production wati nayefuluma naye ng'ate ye file tantuuka wamulamuzi nti registrar tanaloketinga mulamuzi nakubadde lawyers ba Besigye bagamba nti omulamuzi ono yasalawo abetwogerera weyajja abetwogerera Dr Kizza Besigye atuusidde wansi wetuli tetusobola kubanga tumwakisesinga wansi olwokuba nti kooti ekubye bugule ayingira tafuluma bwogeza nogamba nti oyingidde oba tofuluma so kati naye nga ye Kizza Besigye akutuusibwa era nga okusiza ku environment bweraga Kizza Besigye atuusiddwa wansi mu kaduuku gye batereka nga bakavweruzira naye nga ye atuuse tumulabyeko nga ayingirawo buterano so ate wano ku kooti sokulaba nga oba oli awo tukutuusaako embeera nga bweri kinajjukirwa nti Dr Kizza Besigye yakwatibwa ennaku z'omwezi nga 16 omwezi ogw'okumu omwaka 2024 era kinajjukirwa nti TikTok oba Alternative Uganda Facebook na YouTube page feffeka abasembayo okumukyaza oba okugerako eri bannamawulire mu programu eyo ey'essaawa 2 era yagera ku PDM era nga yagamba nti PDM yategeza nti PDM alinga sitaani yajja okutta okubba n'okuzikiriza nti kubanga President Museveni ne gavumenti yeseze badde mu bannayuganda aziza babalimba nti ate babawa so eyo programu abasembayo eri ku YouTube osobola nga oginoonyako bagikola nga z'omwezi 15 then nga 16 n'akwatibwa era programu yennyini yali ayogera ku nsonga oba obuvunanyizibwa bw'abannayuganda bali mu diaspora eri enkulaakulana y'eggwanga edemokulasia so gwe nawe naga okulaba emu ku show eyasembayo oba appearance ya Besigye eyasembayo genda ku kooti genda ku peji yaffe eyokubanga omulaba so naye nga tumusuubira kubanga bamuyingiza kuba ye atuuse era nga tumulinda kulaba nga sawa yonna tumulaba nga ayingirawo nnyo ddala mukono
njakuta mama
Wanji? Oba tugenda guteekawo ewanatwanguyiza
mulabe waffe esawa yonna tujja kuba tulaba Dr Kizza Besigye nga aleetebera bulaba abapurizoni abo omanya nti Kizza Besigye waali nnyo era nga atuusiddwa so kajja konna tukuba nga tumulaba kano Dr Kizza Besigye so gwe omulabe waffe yonna omulungi tukwebaza okubanga kyali naffe so bannamateeka bayingidde dda eno esaidi ya gavumenti oba eya state ngaekulembeddwa oyogola bamuyita Richard Birivunduka senior state Antony yakulembeddemu tiimu yonna so okulaba nga badifendinga oba nga balwanirira gavumenti ya Uganda obanga bavunaana Kizza Besigye ne munne. So bali eyo bannamateeka ba Kizza Besigye ne Hajj Obeid Lutale Kamulegeya nga bw'obalaba awo mu mbeera bw'etyo eri. So naye bafa omulungi ndowooza bwekiri embeera eri era embeera
yamba kansi ekitabo ky'ebimuli yakijjeewa kumbe kikyo any signs of the two gentlemen to get bail. As of now, we can't ascertain because it's the judge who has the powers to determine whether grant or not, bail granted or not. So as of now, we can't ascertain and we can't preempt because even not even lawyers can, as of now, tell whether bail can be granted or not. So I think that question is, as of now, is hard for us to answer. Yes, true. Security has blocked a couple of people outside, specifically those that who seem to be connected or friends, relatives, colleagues of the two bail applicants. That's Kizza Besigye and his aide Hajj Obeid Lutale. So yeah, true. A number of people has been blocked from accessing the court, and even though the court is filled to full capacity, meaning that even if they are granted access, they might face challenges of getting where to sit or even standing. So yeah, it's true. Now a couple of numbers. Now people have been blocked. That's what I can say. I'm from Kasanda. Abemugende batulabire bagambe tubatumiddeko nnyo naye nga naffe tuli tukwebaza olw'okuba nti mukadde kano naawe otowakaddatako n'akaddeko osobola okulaba nga tugobera naye nga yo kooti ekubyeko obugule so olina woyisa kigere so gwe nawe naatanaja ku kooti tosuubira kulaba okuba nti ojja kufuna woyimira kubanga n'abantu bennyini abamu bagaaniddwa okuyingira naffe bannamawulire abamu babadde bagaaniddwa naye olwasolidate gye tulina tusigezaawo okulwanirira bannaffe ne basobola okubanga bayingira newankubadde era eri abo abatafunye ennyo obuzibu okuyingira naye nga sawa gyenalina omulamuzi ayingira okusinziira ku sayizi bwe ziri omulamuzi baguma okujjako nga yaguvuddemu obanga waliwo omuntu omulala agenda okukwata naye nga omulamuzi baguma yagusiba okubanga agulimu nnyo nnyini ddala so ya embeera bwetyo bwekyali era nga tujja kugezaawo kubanga oba oli awo tukuwa updates nga bwe ziri mu mbeera eyo. Olaba bwekikooti ekubyeko obugule tolina kuyisa kigere so bwatanajja oyinza okubula owoyinya oyinza okubula owoyita so embeera bwetyo eri omulungi. This one is yamala yaffe omulungi tubeebaza kituufu buli kimu kitambula bulungi Dr Kizza Besigye aliddwa ali wansi awo naye nga tumulinda ssaawa yonna kubanga oli awo ayingira obanga ajja mu kaguli osobola kubanga azifuna obanga asaba bbeeyi.
Good morning. How are you?
Zayingidde so kati tulinde tulabe ensonga bwe zitambula.
Application 299 of 2025, Dr Kizza Besigye, Hajj Obeid Lutale, Uganda.
Yes,
Nalukoola areas. Moses Tugume, Wanda Samuel Ronald. Tugume Moses. Samuel Ronald. Wanda Ronald. Prospective Kunihira. Kasuku Tobias. Kasuku. Katobiro Wilson. Ohuru Cyrus. Ohuru. Wangala Cyrus. Wangala Isaac. Bayan Trina. Apollo Katula. That's for the applicants and for the prosecution. Thomas Jatiko, Assistant UPP.
That's true, my lord.
Richard Tiripungu.
That is true, my
Thomas Jatiko is the Assistant UPP and Tiripungu is the Chief State Attorney. And finally, George Buyinja, Senior State Attorney.
That's correct, my lord. Richard Chief State Attorney.
Yeah, Chief State Attorney, my lord.
On the side of the applicants, we are ready.
My lord, the respondents are ready to proceed this month.
Let us proceed.
How do we propose to begin with the application for mandatory bail?
This is report 399. 399.
Yes. This is the one for mandatory bail. And Council President Fanga will open the argument.
If you may please quote, my lord. President Fanga, my lord. Criminal Notice Application number 399. It's an application for a single order. You have the applicants 399-2025. This is for a single order to admit the applicants. And retired Dr. Kizza Besigye and Hajj Obeid Lutale, the mandatory bail. So that they are released from custody where they have been on remand since the 20th of November 2022. My lord, for brevity, the laws since November 2022. My lord, the provisions of the law under which the application is brought are stated in the notice of motion. But the first is in Article 23, sub-Article 6, paragraph C of the Constitution of the Republic of Uganda. My lord, that application is supported by the affidavits of the applicants. And in response, when we joined the affidavits in response of the state, the applicants swore their filed affidavits in the joint. Our colleagues, the state were served with the affidavit, the notice of motion, the affidavit is support, the affidavit is the uncontested facts that the applicants were arrested on the 16th of November 2024 in Nairobi. They are contested, they are not contested. Reading the affidavits, those facts that the applicants were arrested on the 16th of November 2024 in Nairobi, Kenya, since November 2024. They were produced and arraigned in the General Court Martial in Makindye on on the 20th of November 2024. On the 20th of November 2024, my lord. And were charged with various offences, including offences relating to security, contrary to section 128, subsection 1, paragraph F of the UPDF Act, Cap 330. I know they were charged with various offences, some are the firearm acts, but the one which is pertinent is offences relating to security, contrary to section 1.8, section 1, paragraph F of the UPDF Act, Cap 330. My lord, we state that offence because the penalty for the same offence, if found guilty, is that the accused person suffers.
You say you can compound the charge in this application is under the UPDF Act?
My lord, there was a transfer.
Offense.
There was a transfer of proceedings to the magistrate court. So
What is the current?
the current one, following the transfer now, is treason and treason. My lord, we are making an excess because there is an unbroken trend of the period of remand, which is the issue of Article 2036. So, my lord, and they were remanded on the same day to Luzira on the 20th of November 2024. There was no second remand.
So the remand is
The remand started on the 20th of November 2022. And they have been in remand in custody since that. My lord, following the decision in Supreme Court Constitutional Appeal number 2 of 2021, the Attorney General versus the Honorable Michael Kasuku, it was delivered on the 31st of January 2025. On the 31st of January 2025. The charges were transferred from the General Court Martial to the civilian courts. At the Chief Magistrate's Court of Nalukoola. And on the 21st of February 2025, the applicants were charged under Nalukoola criminal case number 8 of 2025. For the offences of treason 8 of 2020. Uganda versus Colonel retired Dr Kizza Besigye and Hajj Obeid Lutale. Captain Denis Oola is not here, but then those two charges were read to them on the 21st of February 2025, and they were further remanded. I know that forms the gist of our application because, as the court asked, there was no interception of any liberty, not even for a minute, for the accused persons, for the applicants. They were further remanded. So the remand only continued from November, and it was carried on. That's the fact remand. So the applicants have never gained their liberty since the 20th of November 2024. And they have been on remand in Luzira Prison since that day. My Lord, the remand since the 20th of November 2024 exceeds 180 days. To be precise, my Lord, the 180th day approved on the 19th of May 2025. May 2025. My Lord, this application was filed on the 29th of May 2025. Which is the 190th day. 10 days after the constitutional deadline, 29th May 2025. My Lord, correction. According to this, it was filed on the 28th of May. That stamp, we call stamp, physical stamp, on the 29th. I wrote for consistency, and because this court has made a pronouncement in that land, the consistency between the charges in the General Court Martial and the charges at Nakawa is that the penalty for conviction is death. Meaning that the offenses of that nature are not tried by subordinates. And as the court has found, my Lord, an application for bail in that case is brought before the High Court under Article 139(2) of the Constitution. (139)(2) of the Constitution. And my Lord, that is at the decision of the learned brother, the Honorable Mr. Justice Isaac Mwata, in the case of Besigye Enoch versus Uganda. criminal business application number 133 of 2025. Criminal business application number 133 of 2025. I know that decision is intended to cure the lacuna that was caused by the declarations in Attorney General versus Honorable Michael Kasuku and hinges on the decision of this court in the case of Dr Kizza versus Uganda. High Court Business Application number 118. I wrote again the gist of that decision. Is the argument that the days for counting the remand should commence when the accused persons were charged in Nalukoola. February 2025. The decision we have cited which was determined by the High Court took into consideration the remand of Mr. Enoch Mwesi I wrote the argument we are making is that factually the applicants were remanded in November 2024. That the charges now treason charges by Nakawa Case 8, 2025. The Honorable Mr. Justice Mwata. The Honorable Mr. Michael Rubu United Brothers invoked the power of court to cure that lacuna. And in reason there is any uncertainty, the injustice caused may result. I will be content that with using that authority, the time within which to count 180 days, as the decision survives, starts at the beginning, which is the 20th of November, 2020. It's the same state. In the general court martial, which restrained their liberty, but under the veil of the general court martial. It only changed shape and perhaps color when it went to the mainstream. It's the same process. My Lord, the law is very clear. Article 23(6)(c) of the Constitution. That where a person is arrested in a criminal offense, tried only by the High Court, my Lord, just for that when a person is arrested for a criminal offense, in a case of an offense tried only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, the 180 days approved on the 19th of May. And unlike what is stated in the affidavit in response, the applicants were committed the High Court for trial on the 188th day, 8 days after the expiry of the constitutional date. My Lord, that provision is re-echoed bail guidelines for the course of adjudication, open brackets, practice, close brackets, directions 2022, which is legal notice number 8 of 20. And my Lord, it is guideline number 10, paragraph. Lord, the command of that article, as well as the bail guidelines, is that once it is established that the applicant has been on remand, rather, I beg your pardon, that the applicant is charged with an offense triable only by the High Court. This case treason for 180 days without committing. That person shall be released based on such conditions as the court considers. In constitutional reference number 20 of 2025. Uganda, brackets PPP, versus Kano, retired, Dr Kizza Besigye, has found that the court must release the exercise in respect to the conditions for the grant of bail.
Dokita yatwogerera abaaba abasirikale kasita obalaba abo kasita obalaba action time from now. Dr Kizza Besigye kasita olaba abasajja ba prison zaabo omanya kimu oyinza yeah. Video. Kale. Oti bukusigira ba. Oli gwe ngamba. Doctor watukira. Let's make it happen. Baloya be. Council Kato. Kale muyaye. Yakusamu ko muyaye. Ekintu ndowooza mukitegedde we kitambula abakanso be bonna abasinga obungi batuuse dda bumuyaye awo wakumalayo naye eno baaganye otunuzaayo kamera Dr Kizza Besigye back in court. Bwetwogerera kali ke twasoose oteekayo ke tubateereddeyo kawadde ka preamble kakati badde ngamba kansa ekitabo kyebimuli yakijjeewa kumbe kikyo luyimbazi Amina kale nade manyi twakkiriziganyizza kawaggulu ketukwatira awo wansi toyinza genda kwatira le naye banaye nina ebizibu Wanji papa na kompyuta teziri
As of now, because the judge who was the powers determined whether you have followed what is happening or not. So as of now, we can't ascertain and we can't predict.
Oh my!
Because not even lawyers can as of now tell whether you can grant or not. That question is so now we start for us to answer. Yes, security has moved a website specifically those that
You're not even want to get
Kizza Besigye and his aide Hajj Obeid Lutale. So they are true. has been blocked and even the court is filled to capacity, meaning that even if they have granted access.
Anytime from now, ladies and gentlemen, we are getting Dr. Kizza Besigye coming inside, because as we talk, Dr. Kizza Besigye is down the docks and is coming through the court. We are getting prepared. The judge is coming inside the court. We want to know which judge is going to be in this matter. So just a few moments from now, Rimba's Nalukoola is there on to this matter. It is going to be part of this. So choino manyanti court yo yajudde dda abantu bonna webali ab'enjawulo bonna okubanga ensonga zino bazitambuliza ddala bulungi. Sorry. Nkugamba ekintu kimu kyokka nti dokita dakiika emubbiri agenda kubanga ayingidde wano, dakiika emubbiri okusinziira obubonero bwonna obulabika. Dr. Kizza Besigye essaawa yonna okuva kati twegattako. Asooka enveeyo yite.
Waliwo ekigundi mukijje. Ogenda kukwata kiwali kiba ku benchi. Bano we bagenda okwogera n'abaali. Wanosobola bawo wenyimiridde.
Kikolere wange badde
Oli muwanvu n'omukazi
kati tukwatirako nno kamera yiyo ne bino bimadi.
ate nze nkati ngikwate nti.
Kati nze abakyakola awo kyokka nasenkeera ne nyimirira mmanyi nti kati ate oyimbirirwa omanyi.
Must you put here on this?
Tina, towulira mbu mbiteeke wano wembankolera ate kyangu yinire wano
nakuba nsiwulira njagala kuwulira
kikyo
kyenyala okuwulira
njagala ndimukwata bifaananyi mbaviiridde nno nakuyitawo buyisi kati ate mumpambye sikyalina Not comfortable.
Dr Kizza Besigye, Hajj Obeid Lutale versus Uganda.
for the applicants and for the prosecution. Assistant DPP.
That's true, my lord.
Richard Bilikumbuka.
That is true, my lord.
Chief State Attorney. Assistant DPP and Bilikumbuka is Chief State Attorney. And finally, George Ijira, Senior State Attorney.
That is correct, my lord. Richard Bilikumbuka, Chief State Attorney. Yeah, Chief State Attorney, my lord. The second one is
Senior State Attorney.
George Ijira, my lord.
On the side of the applicants, proceed.
My lord, the respondents are ready to proceed with this one. Let us proceed.
Before we propose to begin with the application for mandatory bail,
This is report 399. 399.
yes, it's the one for mandatory bail. As once it's ready, Papa will open the application.
If you may please quote, my lord. Ready, my lord. Giving only this application number 399. It's an application for a single order. To have the applicants, this application is 399 2025. This is for a single order to admit the applicants. And retired Dr. Kizza Besigye and Hajj Obeid Lutale, mandatory bail. So that they are released from custody where they have been on remand since the 20th of November 2022. My lord, for brevity, because since November 2022. My lord, the provisions of the law under which the application is brought are stated in the notice of motion. But the first is in Article 23, Sub-Article 6, Paragraph C of the Constitution of the Republic of Uganda. Lord, that application is supported by the affidavits of the applicant. And in response, when we joined the affidavits in response of the state, the applicant swore were filed affidavits to be joined. Our colleagues, the state, were served with the affidavits. The notice of motion, the affidavit is support, the affidavits. About the uncontested facts, and that the applicants were arrested on the 16th of November 2024 in Nairobi. On the 20th of November 2024. On the 20th of November 2024, my Lord. We are charged with various offenses, including offenses relating to security, contrary to section 128, subsection 1, paragraph F of the UPDF Act, Cap with 0. Although they were charged with various offenses, some under the Firearms Act, but the one which is pertinent is offenses relating to security, contrary to section 128, section 1, paragraph F of the UPDF Act, Cap with 0. My Lord, we state that offense because the penalty for the same offense, if found guilty, is that the accused person suffers.
We say we can somehow the charge in this application is under the UPDF Act.
My Lord, there was a transfer. There was a transfer of proceedings to magistrate. So the current one, following the transfer now, is treason and misprision. My Lord, we are making an excess because there is an unbroken trend of the period of remand, which is the Article 20.36. My Lord, and they were remanded on the same day to Luzira Prison on the 20th of November 2024. My Lord, there was no second remand.
So the remand started when?
The remand started on the 20th of November 2020. And they have been in remand in custody since last week. My Lord, following the decision in Supreme Court Constitutional Appeal number 2 of 2021, the Attorney General versus the Honorable Michael. It was delivered on the 31st of January 2025. On the 31st of January 2025. The charges were transferred from the General Court Martial to the civilian courts. At the Chief Magistrate's Court of Nakawa. And on the 21st of February 2025, the applicants were charged under Nakawa criminal case number 8 of 2025. For the offenses of treason, this number 8 of 2025. Uganda versus Colonel retired Dr Kizza Besigye and Hajj Obeid Lutale. Captain Oola is not here, but then those two charges were read to them on the 21st of February 2025, and they were further. I know that forms the gist of our application, because as the court asked, there was no interception of any liberty, not even for a minute, for the accused persons, for the applicants. They were further demanded. So the remand only continued from November, it was carried on, that's the fact. So the applicants have never gained their liberty since the 20th of November 2024. And they have been on remand in Luzira Prison since that day. I wrote the remand since 20th of November 2024. Exceeds 180 days. To be precise, my lord, 180th days approved on the 19th of May 2025. of May 2025. And my lord, this application was filed on the 29th of May 2025. Which is in 198 days. 10 days after the constitutional date, it will stand on the 29th, 29th. Lord, for consistency, and because this court has made a pronouncement in that matter, the consistency between the charges in the General Court Martial and the charges at Nakawa is that the penalty on conviction is death. Meaning that the offenses of that nature cannot be tried by the subordinate courts. And as the court has found, my lord, an application for bail in that case brought before the High Court under Article 139(2) of the Constitution. 139(2) of the Constitution. My Lord, that is by the decision of your learned brother, the Honorable Mr. Justice Isaac Mwaka. In the case of Besigye versus Uganda. Criminal witness application number 133 of 2025. Criminal witness application number 133 of 2025. And my Lord, that decision is intended to cure the lacuna that was caused by the declarations in Attorney General versus General Michael Kasuku and hinges on the decision of this court in the case of Dr Kizza versus Uganda. High Court witness application. But again, the gist of that decision is the argument that the days for counting the remand commence when the accused persons were charged in Macau. The decision was cited which was determined by the High Court. Took into consideration the remand of Mr. Besigye pursuant to the orders of the General Court. So that the period of remand of Mr. Besigye by the orders of the General Court Martial was taken into consideration in determining the constitutional custody by the time they were charged. For those days when they were in custody, my Lord, between the 20th of November 2024 and the 21st of February 2025 cannot be wished away or set under the carpet. And that is the reason, my Lord, why the Honorable Mr. Justice Mwata and the Honorable Mr. Michael Uganda, United Brothers, invoked the power of court is the High Court. My Lord, the court was emphatic and grounded this decision of use in Article 126(2)(e) of the Constitution, that it administers justice without undue regard to technicalities. So, my Lord, the lacuna caused by the pronouncement
of the Supreme Court which impacted on the charges before the General Court Martial and the remand there. Cannot be visited against the rights of the applicant. As victims of the process, they are entitled to take benefit, and that's where the court comes in. Because it's the custodian of justice. My Lord, criminal prosecution are such that all the resources of the state focus on an individual. In this case, the two individuals before your lordship. So that any breaches of the law of the state cannot be the fault of the applicant. And the state cannot be allowed to take benefit at the expense of the applicant. That was the view of Uganda draft. And my Lord, we are mindful of the fact that in this case there was a transfer. And that transfer is admitted in the affidavit reply. However, it would be absurd for the state to argue that it took over everything about the prosecution except their remand. That's absurd. So who remanded them? They were in a government facility. And my Lord, BIP Kukundakwe accepts my Lord, in their affidavit, I just want to emphasize that. My Lord, in paragraph in paragraph 11 in particular, so my Lord, paragraph 10, if I may read it. The first applicant, and in his evidence, he does state for himself on behalf of the second applicant that on the 31st of January 2025, the Supreme Court of Uganda delivered judgment in the Constitutional Appeal number 2 of 2021, Attorney General vs. Economic Kawaziruka, inter alia, that all trial of civilians before the General Court Martial was unconstitutional. In paragraph 11, that because of the Supreme Court judgment, we were not produced before the General Court Martial on the 3rd of February and were remanded in prison without any lawful remand warrants or charges. And my Lord, in response, which is in paragraph 10 of the affidavit of Okunda, that is the affidavit in reply to the first applicant's affidavit. It says in paragraph in paragraph 9, the contents of paragraph 6, 8, 9, and 11, my Lord, 11, which speaks to their being remanded without lawful warrants in the government prison. Mr. Kundakwe says that the contents in the applicant's affidavit are admitted to the extent of the charges against the first applicant his appearance before the General Court Martial, his appearance before the General Court Martial, and remand. So it's admitted that they will remand. That position is also the same in his response to the affidavit of the second applicant. And in regard to the second applicant, Mr. Mutundwe affirms in paragraph 7, he admits the charges against the applicant, his appearance in the court martial, and his remarks. So, my Lord, to the extent that the people admits that they want to remand, and they stayed on remand, the court should cure the lacuna. And the Lord should be mindful of the fact that there has been no break whatsoever from the events that unfolded in the General Court Martial. It has been a continuous process of remand after remand after remand, with not a second of liberty in between. So we invite the court to invoke its powers in Article 126, Rising Justice, 139(1) of the Constitution, Section 17 of the Dictator Act, to cure that lacuna, to prevent an abuse of justice. It cannot be this court to argue that the remand between November 2024 and February 2025 was no remand. Though the court cannot aid the state to commit wrong. We repeat, it's the same state under the veil of the General Court Martial, which manifested in the power magistrates court. The consistency is the remand, and perhaps the harm. My Lord, be that the case, in the alternative and without prejudice to what we have said, in the unlikely event that the court should agree with the state that the 180 days should start from the charges at Macau, I would say unlikely, because the court cannot ignore the fact that the applicants have been in custody since November. But the fallback position is found in the judgment of the Constitutional Court in what we call the Colonel Besigye reference, number 20 of 2005. Number 20 of 2005, Uganda, DPP versus Colonel retired Dr. Kizza Besigye. but not in that decision, and which was reaffirmed in the constitutional petition number 20 of 2006. The court found that still under Article 23(6)(c), 23(6)(c), an accused person triable only by the High Court, triable by offense, charged with offences tried only by the High Court, and who has not spent 180 days on remand can seek release on bail. And in that case, the court has the discretion to grant or not to grant bail if they fail to show exceptional circumstances. My Lord, the court found that that is the import, that is the only reason, that is one of the reasons, I beg your pardon, why there was amendment number, why there is a Trial on Indictment Amendment Act number 9 of 1990. I know that is the rationale for the Trial on Indictment Amendments Act number 9 of 1998. My Lord, the court argued that in such a case where the applicant comes to court through this article, the court does not consider the conditions for ordinary bail. It only refuses to grant bail on discretion if the accused or the applicant fails to show or satisfy about or regarding the excessive. My Lord, for brevity, one of the exceptional circumstances is age or advanced age. My Lord, in the affidavit in reply of Ukundako, BIP, both in regard to the first applicant and the second applicant, he admits that both applicants are of advanced age. My Lord, as we close, and I close, sorry, not we, I close, because my colleague may want to add. The other objection has been in paragraph 20 and 22, that the accused will abscond from bail. Such plain statement was the case in the constitutional reference point of 205 and the Besigye Stephen case. Again, it was a statement that the accused would have scored because of the gravity of the offenses. My Lord, the court in that case found that that too was a plain statement, perhaps because the state was not expected to say anything. My Lord, we are mindful of the fact and has been shown in Group Annex F of the first applicant's affidavit support. They have been charged several treason, misprision of treason, terrorism, rape, etc. and has not failed to meet any condition because in all those cases it's been released. My Lord, in paragraph 23 of the affidavit in reply, because they are the two, they are more or less the same. The aide Ukundane states that in the prison trial against the first applicant in 2016, he absconded. Well, we believe that abscond must be a finding of court in order to show that there was an abscond. But my Lord, as shown in the affidavit in Uganda, that is not true. Sureties were never penalized, and in fact those charges were withdrawn. My Lord, the impressive aspect that in that allegation or statement, the state supports that with an equalist record. My Lord, to the extent that we are alive, you know that equalists were not there in 2017. So where the state is getting this thing, we don't know. That's the state. My Lord, there's an objection in paragraph 26 regarding the sureties. My colleague will allude to that same time that your learned sister, the Honorable Justice Kanya, in application 133 of 2025, found all the sureties standing according to such. And they are the same. The state has not shown that there is any change regarding the sureties. And the other objection in paragraph 27, which speaks to investigations. We are aware that there has been a committee for that investigation. There are no investigations. The other objection is in paragraph 28 and 29 regarding witnesses in Uganda, Kenya, Switzerland, and Greece. And that the applicants have associates in these countries. It is the same unsubstantiated allegation which the court in Buyinja said should be disregarded. The associates are not right. And in the indictment, there was nothing to show that there was evidence of these actions. But in paragraph 30, the state contends that the followers of the applicants are violent. They threaten the court, they sing loudly, they hold press conferences, etc. The benefit we have today is that, my Lord, you are present. We didn't hear any hymns or songs for that matter. And we don't want to take the view that your Lordship was scared or under attack. So, my Lord, we submit that the applicants have satisfied the requirement to be entitled to get this question. Lastly, my Lord, as I wind up my submission, as indeed the Constitution commands, this application was made in the lower court, because the lower court is enjoined. And the power of the lower courts to do so have been the subject of court findings by your learned brother, as he then was, the Honorable Mr. Justice FMS Mutundwe, in Uganda versus Tesimana Rosemary, Massacre Criminal Revision 13 of 1999, Uganda versus Tesimana Rosemary, Criminal Revision of Courts in Massacre, number 13 of 1999, Criminal Revision of Courts, number 13 of 1999. And again, the Honorable Mr. Justice FMS Mutundwe, and then was in Criminal Revision of Courts, Massacre, number 5 of 1999. That one is Shabuhuria Makia versus Uganda. My Lord, the court, the High Court, informed the lower court that it had the power to intervene in delays of this nature to avert the miscarriage of justice. What I have seen, my Lord, is that the lower courts have been shy or meek or timid to do the right thing. So, my Lord, it is a breath of fresh air that we are before a High Court, which we believe will not be shy, will not be timid, and will not act under any influence, as the learned brothers found in the domestic. We invite court, my Lord, to invoke the bold spirit and not be timorous. so that an abuse of process and a miscarriage of justice is averted. My Lord, I'm closing. I just want to make a final remark. My colleagues have just changed my phone. My Lord, we refer, my Lord, to a land author, Lord Alfred Thompson Benny, in his publication, The Discipline of Law, London, 1979, at page 315. My Lord, if I may quote, if I conclude my remarks. Say that if the powerful still abuse their powers without restraint, if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous soul. It is thanks to the dominant influence of timorous soul. Semicolon. Bold spirits will not let that stand. Bold spirits will not let any rule of law. Bold spirit will not let stand any rule of law which impairs the doing of justice. They will do all they legitimately can do to avoid that rule. Even changes so as to do justice in the instant case. My Lord, it's a prayer of my colleagues now that the court will adopt, unlike the courts below, a bold spirit so that justice is done in the matter before us. My Lord, my colleagues have that.
My Lord, I can address you in two specific areas or other issues. The first one is about the spirit of mandatory. The spirit of Article 26, rather Article 23, sub-Article 26, Article C. My Lord, I make reference to a number of activities that are brought out. Article 23, 23, 26. The spirit, my Lord, the protection and safeguard the sanctity of the right, liberty, as well as guarding against abuse of the body process. My Lord, I will refer you to the decision of Besigye Stephen, miscellaneous application number 021 of 2025. It's a very recent one. My Lord, July to be exact, Justice Flavia, 30th July 2025. And my Lord, on page 4 of that decision, your sister had this to say: bail under Article 23(6)(c) of the Constitution was introduced as a safeguard to prevent the state from keeping accused persons in prison indefinitely without trial, particularly where the committal process has been delayed. The court is therefore required to strike a balance between the applicant's right to liberty and presumption of innocence and the public interest in ensuring that those charged with criminal offences are brought to justice. And she concluded by saying, in doing so, the court should impose conditions that are fair, reasonable, allowing the accused to enjoy the benefit of mandatory bail, while also making it possible to ensure that the accused continues to attend court as required and to be placed. So the point here, my Lord, is that the right to bail under Article 23 was meant to guarantee enjoyment of the right to liberty and also safeguard the processes of this honorable court. The same decision is reflected, my Lord, for rather reinforced in the authority of Dr. Henry. We have our bundle of authorities, my Lord. Dr. Henry, criminal miscellaneous application number 096 of 2025. My Lord, this decision.
My Lord, we don't have those bundles my colleague is referring to, but if it's saying they have some.
My Lord, they are weaknesses, but for the benefit of the state, I can offer them a copy. But they are there on there. My Lord, this is a reinforcement of the earlier decision cited by my friend here, Uganda, the one of Justice Mwat. Now, this one, my Lord, is about, again, Article 23, where His Lordship said, after reviewing the affidavit evidence and the applicant's submission, this court finds that the applicant was detained on remand for over 6 months without committal to the High Court for trial, exceeding the mandatory procedural timeline. The subsequent committal occurring only after this period lapsed must be weighed in the applicant's favor, particularly in the context of any relief sought as bail to prevent further prejudice. The emphasis, my Lord, here is that notwithstanding the fact that one has been committed to the High Court subsequent to the expiry of the mandatory period of 180 days, is not a preclusionary bar to being admitted to bail. My Lord, the case of Besigye Enoch, which is also on record there, My Lord, on page 4, that decision, it is criminal misdemeanors application number 133 of 2025. Which my learned friend made reference to, but mine specifically is about the spirit of Article 23. On page 4, Justice Mwata had this to say. He was quoting with approval the ratio disciplinary in Sabuharia Matia versus Uganda, which is cited there on page 4. He said the court emphasized that the High Court must protect its ability to function as a forum of justice and not an agent of oppression, particularly in cases where a prolonged decision, rather detention, the court emphasized that the High Court must protect its liberty if I read again, the court emphasized that the High Court must protect its ability to function as a forum of justice and not as an agent of oppression, particularly in cases where prolonged detention without trial continues or constitutes an abuse of court process. My Lord, in this particular case, the accused persons have been on remand as of today, have been on remand for 263 days. As of today, they have been at Luzira maximum prison, which is a remand prison. Luzira maximum prison, which is a remand prison for 263 days. My Lord, I will refer you again to the decision of Colonel Dr Kizza Besigye. This is Colonel Besigye versus Uganda. It's bail application number 228 of 2005. and 229, my Lord, of 2005. There were two bail applications. They are there in our bank, my Lord. On page 6, Justice Oola, the principal judge then, emphasized the role of court in protecting the right to liberty. And indeed, he explained the sanctity of this right in the following terms. I have taken into consideration the fundamental importance of bail as the judicial instrument for ensuring the liberty of the individual. In this regard, the quest for bail is a quest for liberty. The right to the liberty of the individual is next only to the individual's right to life itself. You need to underline that. The right to liberty of the individual is next only to the individual's right to life. After the right to life, the next one is right to liberty. And that right. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is so precious a commodity that during the American struggle for independence, some 300 years ago, one of the American independence protagonists I believe it was Thomas Paine, summed up the situation with the following eloquent and immortal declaration. A declaration not of suicide and despair, but of defiance and triumph. That is quite instructive, my Lord. A declaration of not suicide and despair, but of defiance and triumph. Give me liberty or give me death. That sums it up for us. These are not my words, Justice Oola. Liberty is the very essence of freedom and democracy. Now looms large. The liberty of one is the liberty of all. The liberty of anyone must never be curtailed lightly, wantonly, or even worse, arbitrarily. Article 23, clause 6. This is the provision we are emphasizing. Article 23, clause 6 of the Constitution grants a person who is deprived of his or her liberty the right to apply the competent court of law for the grant of bail. I want to sum up what Justice Oola said by reading the following line. The courts from which such a person seeks refuge and solace should be extremely wary of sending such a person away empty-handed, except of course for good cause. Ours are courts of justice. Ours is the duty and privilege, jealous and courageous, guard and defend the rights of all, in spite of all. Guard just the right of all, in spite of all. My Lord, is a very, very instructive word from Justice Oola. This project. They sum up the significance and sanctity of the right, which is next. My Lord, it is the reason the framers of our Constitution made that right mandatory when one has spent 100 days of the month. That's the reason we made it. And my Lord, I want to emphasize the submission of my young friend here in Uganda. Initially, the constitutional order had been provided for 360 days under the 1995 Constitution. It was 360 days. As a nation, we consider that to be irrational and inimical to enjoyment of the right liberty which is granted by God. It informed the amendment of 2005 to reduce it to 120 days. And now, the state is advancing such reasons to derogate from that sacred provision of the Constitution. This court should not be used as a forum of oppression, as cited by the National Branch Justice. This is not a forum of oppression. My Lord, I will recite the last authority on that. Again, Dr. Kizza Besigye, constitutional reference, 2005, 2006. My Lord, on page 8 of that decision, the Constitutional Court unequivocally proclaimed on page 8 that we turn to Article 26, Clause 6, B and C. We accept the general position as stated by both the counsel that the court has no discretion to grant or not to grant bail after the accused has shown that he or she has been on remand in the custody for 60 days before trial or 180 days before committal to the High Court. As regards Article 23(6)(c), this is specific now in this particular case, where the accused person has been in custody for 180 days on an offense tried by High Court only and has not been committed to the High Court for trial, that person shall be released on bail on reasonable conditions. Like Article 23(6), the court has no discretion to refuse to grant bail to such a person. In both Article 26(6)(b) and C, the court has discretion to determine the conditions for bail. My Lord, this is binding on this honorable court. This is a Constitutional Court decision. I don't need to emphasize the point that it is binding. What I need to emphasize again, the right to bail, the sanctity of liberty as it was explained in that decision on page 11, where Barbie is cast on you to balance the two imperatives. There are two imperatives, and these are captured here. The needs of society to be protected from lawlessness and the considerations which flow from people being remanded in prison custody, which adversely affects their welfare and that of their families, and not least the effect on prison remand conditions if large numbers of unconvicted people are remanded in custody. My Lord, these are some of the imperatives. And finally, on page 12, this is what the Constitutional Court said. Remanding a person in custody is a judicial act, and as such, the court should be summoned its judicial mind to bear on the matter before depriving the applicant of their liberty. My Lord, I think those authorities are enough, but probably I also cite one of the FHRI, the last one now, because it was also cited by my friend here, Mr. Mpanga. I'll go to page 36, still on the significance of this right to liberty. The institution of bail is meant to protect and guarantee the fundamental rights of the individual to liberty, the presumption of innocence and the due process of the law on the one hand, and the societal interests on the other. The most important condition is that the accused will return up to his trial and will not interfere in any of the evidence. My Lord, it's about again putting emphasis on the right to liberty. So I think there is no doubt that this right is one of those most sacrosanct rights guaranteed under the Constitution. Now, my Lord, with the authorities I have cited of the Superior Court, which are binding on this honorable court, but also those which we have cited, like the one of Justice Moata and Justice Lamu, granting mandatory bail even after committal, are equally binding on this honorable court, my Lord. We would like to cite the case of Semogere and others versus the Attorney General, Constitutional Appeal number 1 of 2002, on the question of doctrine of precedent, where the Supreme Court, my lord, stated that as regards, of course, they made reference to decisions of Superior Court being binding on lower courts. I don't need to waste your time on that, my lord. But when talking about decisions of your brother and sister justices of the High Court, judges of the High Court, they say as regards its own decisions, the decisions of this court, it would normally be bound by them, except under the following circumstances. One, that the court is entitled and bound to decide which of the two conflicting decisions of its own it will follow. If there are two conflicting decisions, there you have discretion to choose which one to follow. You may not necessarily be bound. But in this particular case, my lord, the decisions are consistent. That even after remand, rather committal, mandatory bail still stands. So that is first proviso is not applicable. The second proviso is that if court is satisfied that the decision was given by impurity, it's our submission, my lord, that going by the doctrine of stare basis, the decisions we have cited are not by impurity, because they formed the gist of the proclamations made by the court in those particular decisions. I want to sum up this point of civil liberties, my lord, by again speaking to the spirit of the practice guidelines. My lord, the practice guidelines on bail the constitutional bail guidelines for courts of judicature, practice directions 2022. My lord, particularly regulation 10, which talks about mandatory bail for offences triable only by the High Court. Clause 2, or rather paragraph 2 of this regulation 10, in the case of a person who has been on remand for 180 days in accordance with Article 23, Clause 6C of the Constitution, the Magistrates Court shall immediately refer the file to the High Court. My lord, I want to draw parallels with a sick person who requires an ambulance. If the file of Dr. Besigye and Obeid Lutale before the magistrate in Nakawa who handled the free trial processes was a human being, if that file was a human being, on the 19th day of May, they would have put that person in an ambulance to the referral hospital. To the referral, because the regulation provides shall immediately, upon expiry of that 180 days, immediately forward the file. And in the same spirit, my lord, regulation 8, time for disposal of the bail application in the High Court. The court shall consider disposal of an application for bail expeditiously, and in any case, within 30 days from receipt of the application. See, one shall be determined expeditiously, but in any case, if court is constrained by some supervening factors, not exceeding 30 days, my friend. All this is meant to emphasize the point that the law accords the right to liberty is sufficiently reserved. And it is the reason, my lord, speaking to the spirit of the law, that under section 76 of the MCA, Parliament directed the magistrate handling such a matter that once 180 days have lapsed, don't do anything else. The next course of action is consideration for mandatory bail. My Lord, for the accused person to continue being on remand up to the present, the 263 days, when all the laws we have cited, the Constitution, the Acts of Parliament, the practice guidelines, the authorities cited, all speak to the urgency of matters relating to the right mandatory bail. In itself, my Lord, is a negation of that spirit. The security that they are still on remand. And as we speak, my Lord, no readiness will be made for the trial. The state is not talking about the trial at all. And actually, for the record, my Lord, there is still the debate. Was the committee made to this division or to the IC? That's where we are looking for a forum where the trial will be conducted for, to the prejudice and detriment of the applicants and particularly the sanctity of their rights. My Lord, the last issue I wanted to speak about the argument that the charges before the Nakawa Magistrate Court are different from the charges that were preferred against the accused persons at Makindye General Court Martial. That's an absurdity. To the travesty of the IC order by Lord, if that argument is accepted by this order. From the facts which are not disputed, as highlighted by Mr. Mpanga here, my land friend, the state is the one that arrested, another actually kidnapped, picked Dr. Besigye and Obeid Lutale from Kenya on the 16th day of November. And it is the very state, Uganda, which preferred the charges against Obeid Lutale and Dr. Besigye, Uganda, in the general court martial. It's the same state, Uganda, that moved the then defunct general court martial to remand the accused persons. When you look at the chain of events, my Lord, after the intervention of the Supreme Court in the matter, because it's well documented, it is the same state that preferred those charges relating to the same file before the General Court Martial. On the same set of facts which are before you. Same set of facts, same allegations. Even the particulars are all the same. Even the countries we are talking about, Switzerland, Greece, Kenya, no mention of anything different from what was reported in. So to purport to treat those as separate charges, my Lord, is stretching this matter. So invite you, my Lord, to dismiss that argument with the point of the. Finally, my Lord, I've address you on the mischief that the Constituent Assembly attempted, keeping people, accused the person is on remand indefinitely. My Lord, this honorable court shouldn't have missing that, shouldn't be treated as an accomplice in the persecution of the Africans. We pray that he did this, but in the command of the day. My Lord, my colleagues will address you on the issue of the sureties, because yes, Stampang has already cited the decision of your dear sister, your land sister, my Lord, your land sister, Justice Comfort, on the issue of the sureties, which has not been set aside in any way overturned. My Lord, we shall continue addressing you the same, because we have those sureties.
You say you want to present them, or you want to attack the other president?
We are adopting those other ones, but making an application. We do so.
Also, counsel for the Africans, and I'll continue. And the breed, the honest breed of the Africans, that they be admitted to mandatory training. I will add a few clarifications. One such clarification is to clarify the nature of arrest. On 16th of November of 2024, what happened on 16th of November 2024, what happened in Nairobi, Kenya? The applicants who are going for a simple launch, Honorable Karwa Mata, was not a mere or ordinary arrest. It was an abduction. So before you, your Lordship, are victims of abduction. That is contained in paragraph 5 of the affidavit of the first Africa in support of the mandatory training. Paragraph 5. Before they were remanded and following their abduction from the foreign capital, they were subjected to incommunicado military detention. They were subjected to incommunicado military detention at the matching military balance. That's for 4 days, 4 clear days. And you are in between 16th of November to 20th of November. The same year, 2024. Before we go very far, this has legal implications because first of all, incommunicado detention is unconstitutional and is a violation of personal liberty. That Article 23 6 protects. But even more poignantly, according to our law, and specifically the second schedule of the 2012 Prohibition and Prevention of Torture Act, Item 2, subparagraph 3, incommunicado detention is a form of mental or psychological torture. So, yet again, before you, Your Lordship, are two victims of psychological torture visited on them by Uganda People's Defense Forces. Torture is a crime, and in this instance, the scene of crime is matching the military barracks, Your Lordship. After enduring torture and abduction, and they are operated above, on the 20th of November 2024, the applicants before you were arraigned. They were arraigned before a kangaroo military tribunal. They were arraigned for a kangaroo military tribunal. That military tribunal was at Machi. It is like 1 kilometer away from the scene of crime. They have never been seen since then. They have never been free. That's why they are coming before you. Those facts I must emphasize are not mine. They are contained in paragraphs 4 and 5. Signed statement of the first applicant, paragraph 4 and 5. You're under the duty of releasing the applicants from the account of mandatory bail rests primarily in the court.
My Lord, just a moment. I think this is just overwhelming court review. It's my colleague is simply overwhelming court review. You have the right to reply. Most of that. So, before I was rudely interrupted by the conductor, I was involved in the talk. The fact that even if the applicant has not applied, even if the applicant has actually not applied, that's not a prerequisite for mandatory bail.
the application for mandatory bail is not a prerequisite for mandatory bail. The prerequisite for mandatory bail is the infraction. The infraction of 180 days for capital offences. It's not an application. It behoves the judiciary, but specifically the trial magistrate, one, to count the days, to be aware of how many days they choose it before the person has spent on remand. And as soon as they clock 180 days in the case of capital offences, pursuant to section 76 that has already been alluded to from the Magistrates Court Act, the magistrate can simply release. It is as simple as that, although some people want to complicate it. Now, your Lordship, if the magistrate does not want to release the applicant following the parent law, there is subsidiary law called the bail guidelines. Because for me, there should be no debate between the conflict between parent law and subsidiary. But in case the magistrate has any doubts about what to do, they should follow regulations 10 of the bail guidelines and immediately refer the file to the High Court. And once that file is referred, again in sub-regulation 11, the registrar of the High Court or the Criminal Court which the matters are referred is obliged, it's not requested, is obliged by the bail guidelines to shield them, and of course mindful that the court should resolve the matter within 30 days. The reason the magistrate is assumed to know the remand days because every remand your Lordship happens under the remand warrant. Every remand happens under the remand warrant of a judicial officer and before committal specifically of the magistrate. Your Lordship, the magistrate cannot feign ignorance that somehow I did not know that the applicant before me, the accuser before me, has not spent 180 days, because every mention they have to be aware of how many days that the accused person has spent on remand before further committing them on remand. Your Honor, it is the argument of the state that they are about chance. The reason they are objecting, one of the reasons objecting to the mandatory bail, which is an unconstitutional reason, of course, is chance, press conferences, and yes, chance and press conferences. I want to say that those are constitutionally protected rights under Article 29. And a thorough reading of Clause 1, Article 29, would preclude the state from citing it as a ground for objection. The related objection, Your Lordship, is that it is in paragraph 29 of the reply, of the state's reply, and it says that the accused is of a high profile paragraph 29 of the affidavit of conduct proceedings. The reason is that the accused are high profile, influential, and command a big following. Your Lordship, few statements are astounding as this in the journey of the legal profession. So you are being invited on record in writing, Your Lordship, that you stop the bail, the liberty of the accused simply because they are high profile, influential in society, and command a big following, and they have the audacity of including this in the sworn testimony and filing it on the record of the High Court. Your Lordship, high profile popularity is not a ground for denial of liberty, even if you are not mandatory bail. I think it is irregular for the state to be envious of the accused. The point of liberty has been first clarified, but one of the fundamental points of the mandatory bail is actually to stop trial without detention. Detention without trial. And these are not my own words, these are the words of the Constitution. And the Constitution adopts them in the Article 43. The twin purpose is prevention of political persecution. Again, Article 43 succinctly and expressly outlines that. It is a factual reality that the accused are being politically persecuted. Although it goes without saying, the accused have taken the trouble to outline it in paragraph 3, rather paragraph 13, paragraph 13 of their affidavit. Paragraph 13 of their affidavit talks very clearly about the political persecution that the accused have had to endure. So I will end by clarifying the issue of mandatory bail, especially the fact that there was a transfer of charges. This followed a Supreme Court decision. And unless the state is saying that it defied the Supreme Court decision, and it did not transfer the charges, but of course, the facts will betray them. Your Lordship, what changed was only the courts. The fact of remand itself had never changed. Howsoever framed the charges that were in the court martial are still here by order of the Constitutional Court. The idea is that the facts are the same, have not changed, and the law is on the principle of equality and double jeopardy does not allow, it's not even that the state can now introduce new facts. The state, the Constitution on fair hearing does not allow twisting facts so that on the basis of the same fact you bring a multiple charges, you keep tinkering with the nature, the legal nature of charges while you're using the same fact. That is not allowed. And in any event, it would have been prohibited by the order, express order of the Constitutional Court. So they accused, all the applicants have been remanded by 4 courts. The first court to remand them was the Kangaroo Military Tribunal, 20th of November 2024. Following the Supreme Court judgment, the applicants made an application to the High Court Civil Division for habeas corpus. They argued it. And on one of the questions they argued it, that was there, the guy was from, was here. Yes, so they were remanded by that court. Even for their ruling habeas corpus. Then they were remanded by magistrates court in Nalukoola, and then they were remanded by the criminal court, the criminal division here. That is just where most of that. I will leave the floor to my colleagues to address the
I was so trying to say that I'm very grateful. Yes, rotating on the same grounds. Yes, kindly think let us restrict on the points that are going to be raised by another party.
Marshal Price, my Lord. Luyimbazi Nalukoola. My Lord, I don't consume a lot of time, but rather only 2 minutes. My Lord, you have a simple task today, only to implement a constitutional commandment. Which is provided for under Article 23(6)(c). My Lord, the provision is in respect of actual bail. Our application, my Lord, is not for a discretionary bail. And indeed, my Lord, the bail we are seeking, today the applicants are not here for a right to apply for bail. But rather to receive a bail, my Lord. That provision was deliberate and intentional by the framers of the Constitution of 1995. Deliberate and intentional. It was premised on, among others, the oppressive and imprisonment without trial, which was characterized, which characterized our political history, my Lord. My Lord, denial of the right to a mandatory bail by the applicants now before you will be so detrimental to the values and wishes the framers of the 1995 Constitution intended to achieve, my Lord. My Lord, I invite you, my Lord, to stand tall over the unsubstantiated allegations advanced by the state. To persuade you not to grant the application, my Lord. My Lord, I beg to rest.
I have only one or two things to say. Firstly, to reject the proposition in the paragraph 17 of the respondent's affidavit that the applicants have only spent 167 days. We just want to emphasize that there is only one state, and that is the state of Uganda.
Says they have been, they have been remand for only
167 days. They deliberately refused to account for the period between 20th of November 2024 and 20th of February 2025. They admit that period in their affidavit, but they refuse to account for it. And I've said there's only one state, and it is the state of Uganda that was holding them in that period, which is 90 days. So if you add 90 days to the admitted 167 days, that's a whopping 257. But if we count up to today, it's 263, as indicated by my colleague, Elias Ipon. You have the final word. Count the dates from actually the date of arrest. The date of arrest or abduction in Kenya by Ugandan military, in the Kenyan military. That matter is subject of a case in the court of Kenya. The other point, you have been told that the applicant, the first applicant, has been in many cases. What the prosecution is saying, this is in paragraph 18. They even cite an existing case, which is case number 624 of 2023. Kindly note, my Lord, they are not talking of convictions. They are talking of prosecutions they have mounted against him without securing a single conviction. Prosecutions designed to keep the first applicant in custody, just like in this case. You can only put previous antecedents when a court has pronounced itself and there is a conviction. for the case that is pending before the Nakawa Court 624 of 2023 criminal case, the prosecution cannot have their case undated. Why have they not concluded the prosecution since 2023? You come to cite a case where again you are guilty of laches. The associates who are accused of singing are not named, nor are tapes of what he finds, the music that he finds not good, not so melodious to his ears. So it's a mere allegation. And what if others have sung? Are these two applicants going to be punished because others have still sung? We are asking the court to ignore. Finally, I just want to remind the court that Article 126 of the Ugandan Constitution, which we happily borrowed from in Kenya, clearly states that judicial authority comes from the people of Uganda. It is to be exercised in accordance with the Constitution, which has been amply cited to you by my worthy colleagues who have elaborated on the law applicable in this case. The Constitution also clearly states that it is the supreme law of the land. So I'm most respectfully telling the court that it has no option but to grant bail on terms, such terms as are reasonable, especially because the prosecution, as per the affidavits, have no compelling reason why the court should not. Before I hand over to my colleague, Mr. Kalibara, to talk about the sureties, I want to seek the court's indulgence. I came a few minutes late because it came on a day flight. I'm also seeking to leave now because I'm on a flight to Nairobi at 4:30 because I have a funeral to attend tomorrow. So I seek the court's indulgence. I'll be leaving, but I'm comfortable that I'm leaving to a team that has performed so well and continues to
My Lord, I is simple task to introduce the sureties to the court. My Lord, in respect of the first applicant, we have lined up a total of 7 sureties. My Lord, 4 of those 7 sureties namely the Honorable Ibrahim
Seven for each.
So that's the debate I was
each.
The debate I was having with my colleagues. Because the first 4 that I was saying, I was naming were sureties, petition 113, 25.
Webale kulaba KKTv Uganda. Get informed and updated on issues around you and the globe as well. KKTv. Thank you for subscribing to KKTv. Webale kulaba KKTv Uganda. The inspiration and the best broadcasting around town. KKTv. The global experience. The might. The power. And all you need with KKTv. We are your broadcasting experience. Thank you for subscribing to KKTv.
Museveni eranga bwe yakyogedde yayogera n'abantu abalala neffe tetulina kye twogera naye kuba aliwo mu bumenyi bw'amateeka. Ekyokubiri tetwetaaga kwogera naye kuba obuyinza si bubwe, obuyinza bwa bannayuganda. So tetwetaaga kwogera na Mwai Museveni. Ye okwogera n'abantu tayogera ku ngeri ggwanga gye likyuka naye abeera ayagala kwogera naawe kubuuza oyagala ssente meka. Ffe tetugulirirwa.
Bakikola okulabisa okulaga nti tolina kyoli.
You are watching KKTv.
Kikulaga nti eno gavumenti ya Museveni eriwo mu bumenyi bw'amateeka, tegondera amateeka, tegoberera amateeka, yo ekola byeyagala. Omuntu omu yasalawo, bwasalawo nti kati beera mulamu ng'obeera mulamu, bwasalawo nti kati beera mufu ng'obeera mufu.
Mr. Update Kanumbe, oba bankuba bankube, oba banzita banzite, oba kyekigwawo kigwewo.
You are watching KKTv.